Hey boys and girls, today we're diving into a crucial topic in the world of contracts and business deals, representations and warranties. Now, whether you're a seasoned business professional or just starting out, understanding these terms is essential to protecting your interests in any agreement. First, let's define what are representations and warranties. These terms are often used interchangeably and used together, representations and warranties, but it serves distinct functions in a contract. A warranty is a promise that a particular statement made is true at the date of the contract. That said, it can relate to current or future conduct or facts. A good example is the supplier warrants that it has sufficient stock to fulfill the distributor's orders in connection with this agreement. Contracts for the sale of goods often contain additional warranties about the condition, fitness, or adherence to given specifications. A breach of a warranty gives rise to a claim for breach of contract, the main remedy being damages, money. You get money for a breach. Warranties are also frequently used in the sale of business contracts. A seller of shares would almost certainly warrant something along the lines of the sale shares constitute the whole of the issued and paid up capital of the company or credited as fully paid, or there are no encumbrances, charges, mortgages or liens over the sale shares, i.e. the shares belong to the seller absolutely. Why? Because as a buyer, you want the seller to make such a statement that whatever that, for example, if he's buying 10,000 shares and it is the entire share capital of the company, from the buyer's perspective, he wants the seller to make give a warranty that the 10,000 shares is really comprising the whole of the issued and paid up capital of the company. And from the buyer's perspective, he also wants a warranty that there is no charge over these shares. That means he did not pledge the shares, he did not there's no mortgage over the shares, he did not borrow money, and someone else has a superior title to the shares. Representations, on the other hand, are statements of a past or present fact made by one party to another during contractual negotiations, which the other party relies on and is induced into entering into an agreement. I repeat, representations, technically, on the other hand, representations are statements of a past or present fact, okay, which usually occur before entry into a contract, which induces the other person to enter into it. For example, a seller tells a buyer that a company has no outstanding legal disputes, has paid all salaries, there are no MOM, there are no IRAS investigations. That's a representation. It cannot be something in the future. It cannot be something like the company, if you invest in the company or you buy the company will make at least 2 million a year. If you buy or invest in the company, this or that will happen. These are statements relating to the future and are not representations. And if the representations turn out to be untrue, it would amount to misrepresentation, and the party being affected, the buyer of the shares or the company, can rescind the contract. Rescind means cancel the contract. The key difference between a representation and a warranty is the remedy available to the person being affected by the breach. If a warranty is found to be untrue, the innocent party will be entitled to damages. As I said before, he gets paid money, but he doesn't get to escape from the contract. A breach of warranty does not allow the innocent party to cancel the contract. Therefore, if there's a breach of warranty in a sale of business contract, for example, a buyer cannot say, no, take back, I'm cancelling the contract. Take back the company, I'll give you back your money. He cannot do that. That's called rescission or cancelling the contract. In contrast, If a representation is found to be untrue, the buyer or the investor will be entitled to bring a claim for misrepresentation and may rescind the contract. Where a false representation is made fraudulently, the claimant can be awarded tort damages, which differ from contractual damages. Also, the manner in which damages are calculated differs for a breach of representation claim versus a breach of warranty claim. Under a claim for breach of warranty, damages are usually assessed at the time of the breach. Under a claim for breach of representation, damages are assessed from the date the misrepresentation was made. This is usually an earlier date, and so this may give rise to a higher amount of damages due to the time. You made the misrepresentation on the 1st of January, only by 1st of October, it is found that the representation was untrue. So there's a longer duration, longer period of time. If you are familiar with such contracts, you may have seen the word such as the seller represents and warrants that A, B, C, D, E, F, G. Where the wording is clear-cut, like that, it is likely that the court will view the statement as both a representation and a warranty. However, where the wording does not expressly provide that a warranty is to take effect as a representation, an innocent party will struggle to argue that the warranty is also actionable as a misrepresentation. So, to conclude, representations and warranties may appear similar on the surface, but the remedies available can be completely different. The question of whether a statement is a warranty, a representation, or both will depend upon the wording used and the context of the contract in question. Careful drafting of representations and warranties, as well as any exclusion clauses, is therefore important. Thanks for watching this video on representations and warranties.